Start para. The present appeal arises out of the impugned judgment and order passed by the learned ad hoc additional sessions judge, Dhude, dated 31/12/2004 in sessions case number 26/2004, full stop. By way of impugned judgment and order, though both the appellants came to be acquitted from the offences punishable under sections 306 and 506 of the IPC, however, they are convicted for the offences punishable under sections 342 and 348 of the IPC, full stop. Sentence awarded in 1 year simple imprisonment and 3 years simple imprisonment respectively, with fine of ₹1,000 and ₹3,000 each respectively, full stop. Para. The story, in short, of the prosecution is that deceased Rekhabai was working with the present accused as maid, full stop. Even her mother was also working as maid prior to deceased Rekhabai, full stop. The accused thus, had full faith in the deceased, full stop. It is alleged that deceased Rekha had stolen some gold ornaments from the house of the accused persons, and because of that suspicion they made enquiry with the deceased, full stop. On 3/12/2003 at 9 am, deceased went to the house of the accused for work, full stop. At 12 noon, the accused persons made enquiry and stated interrogation, full stop. It is alleged that she was confined in the room till 1 o'clock and thereafter she was taken to the police station, full stop. Deceased thereafter committed suicide on 4/12/2003 at 6:30 am by pouring kerosene on and setting herself on fire, full stop. Because of shouts, her mother, father and brother and her husband started extinguishing fire and immediately took her to the civil hospital, full stop. In the civil hospital, she succumbed to the injuries, full stop. Para. While in the hospital, two dying declarations came to be recorded, that is Exhibit 9 and Exhibit 10, full stop. First dying declaration, Exhibit 9, was recorded by PW2 Karbhari, who was working as ASI at Azad Nagar Police Station, full stop. Another dying declaration, Exhibit 30, was recorded by PW8 Kailash, who was working as Awal Karkun in Tahsil office, full stop. In the second dying declaration, the deceased stated that she was working as maid in the house of the accused person, full stop. On 3/12/2003, she went to their house at 9 am, full stop. The accused person alleged that she has stolen gold earrings of 30 grams. The accused person confined her in a room and put a lock, full stop. In this dying declaration, she stated that since the accused persons have lodged the FIR against deceased, she committed suicide by pouring kerosene on herself and setting on fire, full stop. Para. On recording, the evidence of the court found that deceased committed suicide because of the fact that husband wanted to marry second time, as Rekhabai was issueless, and acquitted the accused from the said sections, full stop. So far as section 342 and 348 are concerned, the learned trial court held that the prosecution has proved that the accused had wrongfully confined the deceased for the purpose of getting confession, full stop. Para. Learned advocate Mr. Kale for the appellants forcefully argued that the court has held the offences are proved only on the basis of two dying declarations. However, both the dying declarations are not proved by the prosecution beyond reasonable doubt. Full stop. There is a doubt created about contents of the dying declarations. Full stop. It has come on record that while recording dying declaration, parents and brother of the deceased were present. Full stop. Secondly, that both the witnesses who have recorded the dying declaration have stated that while recording the dying declaration, doctor was not present for entire time. Stop.